I think there are several ways in which you could see the idea, certainly the kind of mythology that's developed around Magna Carta, as an example of bad history in a number of forms. Firstly, that idea of a kind of immemorial constitution. That's really something that is itself founded on some medieval, creations of this idea of an Anglo-Saxon constitution. You look at things like the so-called, confessors' laws, which are these post-conquest creations of laws supposedly created in pre-conquest Anglo-Saxon England. So there's that element to it, of that conception of this immemorial constitution, and this sort of post-conquest development of that notion of an ancient constitution. But then there's also, I suppose, the much broader sense in which there's an ahistorical element to it, or a distorting element to this narrative about Magna Carta, which is this idea of a kind of a tradition of British liberty spanning back, to time immemorial, with greater and greater accretions of kind of rights and freedoms over the centuries, culminating in the democracy that we have now. And I think there are several ways in which you could sort of talk about that as being bad history. First of all, it's very obviously present-centred. So you're saying, well, the way to view the history of the 13th century is through the lens of the 21st century and some conceptions of what democracy and rights and constitutions are now, not in the terms that they would have been understood at the time. The other way in which, of course, I think it's bad history is just this sort of idea of this broad teleological narrative of ever-increasing freedom. And certain aspects of this, particularly this British story, it's not just this idea of sort of, that there's this sort of steadily progressing onwards and onwards to greater and greater freedom. It's also that it's a narrative with a very particular focus. So we get this idea really that 1215 is sort of it's almost like it's a proto-clash between king and parliament, although it's obviously just the barons, that it's really a sort of prequel to the bigger struggles that go on in the 17th century between king and parliament. And I think it's no coincidence that Magna Carta usually gets mentioned in conjunction with 17th century documents, the Petition of Right of 1628 and the Bill of Rights 1688-9. And so it becomes part of this narrative about Parliament resisting the power of the king, Parliament securing liberties and freedoms, wringing them from the monarch. And what's excluded from that? Well, there are various things that are excluded from that. You get an exclusion of any other kind of forms of agency. So the idea that, for example, popular demonstration or popular struggle might be the story, part of this story of the acquisition of British liberty, isn't part, I think, of that dominant narrative. Whereas if you were, for example, to look at the United States, obviously popular resistance, popular demonstrations are a really integral part of that narrative about American sort of ideas of freedom and liberty. I think the other aspect of it is about, what is the nature of this liberty itself that's being described in this idea of British liberty. And if you look at that sort of, particularly those sort of, 17th century text, the 17th century description of that material, it's obviously excluding certain significant groups. Most obvious exclusion is of women. As Mary Astle said, how is it, if men are born free, that women are everywhere slaves? These sorts of questions are not sort of a part of that narrative of liberty, I think. Similarly, if you look at kind of, certain religious groups, Catholics, Jews, they're excluded from this narrative about liberty. And it's actually really becomes more of a masculine and Protestant narrative about freedom. So I think there are, there's the idea that it's sort of, a reaffirmation of an immemorial constitution, which can't be sort of, verified in empirical terms, and that's, one element to it, which is sort of bad history. And the other element is this sort of present-centred focus, this teleological sort of narrative of ever-broadening freedom, but focused on the actions of Parliament, focused on sort of parliamentarians, or those who are seen as substitutes of parliamentarians like the barons in 1215, basically securing the freedoms, and no other forms of agency are material to that. I think one consequence of it is this idea that, in a way, innovation and, if you like, thinking from first principles almost is culturally inimical to sort of British constitutional life, and that it's always about tradition, custom, and sort of the recovery of already existing rights, rather than some kind of determination of what the political needs are in a particular moment, and therefore, what sorts of rights and freedoms need to be secured. So I think that's, one consequence of it is a sense in which I think still persists, in which there isn't a sort of welcome discussion of constitutional principle. It's always seen as something kind of unsettling, and in some ways kind of un-English or un-British to actually invest much discussion, perhaps, in constitutional principle. I think the other aspect of it goes back to what I was saying about who's kind of excluded from this narrative of British liberty, and I think it's a kind of discussion of liberty which diminishes the involvement of ordinary people in that dialogue. I mean, you can think of the words of that, the Kipling poem about Magna Carta, about Runnymede, where he talks about Magna Carta being there not just to restrain the monarch, but also the mob, as he puts it, if they lay too kind of heavy a hand on English liberties. So it's really this sort of sense in which actually it'd be dangerous to ask the hoi polloi, if you like, what they felt about political arrangements, what they felt about their rights and liberties. I think it can be quite a restrictive understanding of liberty in a couple of senses, both that sense of it as sort of, more about recovering existing rights than developing new ones, and also in that sense of, only certain political actors should really be involved in that process. In talking about this sort of mythologizing of Magna Carta, it's still important to remember, I think, that in I'm not a medievalist, but I think still in the context of the 13th century, this is a radical document, and in some ways, actually understanding the radicalism of the document in its own time can actually help people understand some of the misrepresentations of the document later on. In fact, I think actually the 1215 Charter doesn't fit very nicely into that story about steady kind of constitutional progress, because it's really a much more fundamental assault on King John's power. It's not a kind of, let's create a limited constitutional monarchy. That clause which says that we need this council of 25 barons who will basically decide, whether what John is doing is good or not, that's really about sort of, taking away all of John's authority as a monarch. So it's a much more thoroughgoing challenge to monarchical power, I think, than that sort of narrative about sort of, gradual constitutional change implies. So I think in the context of its own time, in the 13th century, it is a radical document. And I think actually the changes that then happen in the subsequent couple of centuries in terms of how its clauses are interpreted are also very important in terms of the development of ideas of rights in this country, that you move from this more limited description of rights to free men to much broader understanding of it applying generally to male inhabitants, and also that certain clauses, chapter 39 of John's chapter 29 of the chapter that becomes part of law, where it talks about judgment of peers, that then gets interpreted over the later medieval period as trial by juries, meaning trial, that particular form of legal process. I think those things are, we shouldn't kind of underestimate how important they were, how significant they were, and how much of a change they represented, as it were, from what had preceded So I think it's important to think about that, and then in some ways, seeing that original context helps you to understand the way in which some of that repackaging over the 17th and 18th centuries, 19th centuries in particular, is actually stripping away, to some extent, some of the more radical, revolutionary aspects of the original document, and presenting it more as this sort of more moderate kind of a constitutional package, presenting it as something that's, I mean, it's almost like a kind of, well, this is sort of a precursor of the Glorious Revolution and the offer of the Declaration of Rights to William of Orange, and it's not that kind of, we're not talking about that sort of scenario in 1215. So I think actually, understanding its original content can help us understand something about, how far it's been mythologized. Although, of course, it is a document that I think has continued to be used in various ways by various political groups. So while there is that narrative that I've been talking about sort of steady constitutional progress, there is, I think, particularly in the more modern era from late 18th to 19th century onwards, a different kind of narrative developing about Magna Carta, which fits it into a noticeably different story about the development of political rights. And that is a story, I think, that emphasises more 1215 as a kind of exercise in people power, and fits it more into a narrative that might contain things like the Peasants' Revolt, or the English Revolution, for example, and so concentrates more on the involvement, rightly or wrongly, in terms of the accuracy with regard to 1215, but concentrates more on the involvement of ordinary people in effecting political change. And you can see that in Chartist uses of Magna Carta, or suffragette uses of Magna Carta as well in the 19th century, where they're obviously making much broader claims in terms of rights on that, in terms of voting rights, in terms of even sort of economic and social rights, and sort of proto-welfare state being seen as sort of embodied in that 1215 charter. I think that's quite a useful way of thinking about it, actually, that there are these sort of variety of readings of Magna Carta which have developed over time. I mean, one of the leading historians of Magna Carta, Sir James Holt, argued that really after the 18th century, Magna Carta became this kind of the preserve of the radicals, and it was being used in this sort of anti-establishment, sort of more revolutionary, radical fashion. I think the use is more varied than that, and has continued to be more varied than that. I think there's an understanding. There are sort of conservative understandings of it still prevalent, and there are also more radical understandings which are still evident today in terms of the political use of Magna Carta. And sometimes those strands, if you like, intersect. And one of the interesting things for me is if you look at very recent debates where Magna Carta has been invoked, for example, over whether or not Britain should continue to be sort of party to the Human Rights Act, whether it's necessary for Britain, with its own tradition of liberty, to have this kind of essentially European act imposed on it. The rhetoric there about sort of native liberties, and the idea that we don't need something like the Human Rights Act because we've got our native repository of rights like Magna Carta. I think some of that rhetoric actually stems back to 17th century radicalism and the language of people like John Lilburne, who were invoking Magna Carta as part of the rights of the freeborn Englishman. And now obviously the Levellers are talking about really radical political change. They're talking about radically opening up the franchise. They're talking about creating sets of reserved rights which the executive and legislature can't infringe, all sorts of constitutional changes. So this is a political radical in the 17th century, arguing from the basis of these so-called native freeborn rights. When we get to the 21st century, we've got conservative politicians, conservative MPs, using that rhetoric of kind of native rights to actually argue for something which is in some ways about rejecting this particular suite of rights which have been created through the Human Rights Act and enforced through European Court of Human Rights. So I think it's not just that there are these different sort of competing narratives, it's also that at certain points these narratives kind of intersect and flow over each other, which I think is another really interesting aspect of Magna Carta. And one of the things I think just Magna Carta is a brilliant example of is just the flexibility of political language and the way that political language and discourse can change over time and according to situation and context. So I think it's a wonderful lens actually through which to see kind of political ideas change over time. No, I think there is an awareness of it. I mean, if you look at the late 17th century debates over sort of ancient constitutionalism, including documents like Magna Carta, really central to it, there's an obvious awareness of the previous sort of readings, particularly sort of the importance of Sir Edward Coke's work, and a desire to critique that and to sort of reevaluate that. So that process does go on. I mean, obviously it's a process that's also tied to advancing particular political positions. So you have Tory figures attacking that sort of Whiggish narrative, and they're doing it for their own political reasons. But at the same time, they are making good empirical points about some of the problems with ancient constitutionalism in terms of the actual constituent parts of these documents and the actual circumstances in which they were created. So there is I think a critical aspect to this discourse. I mean, even within the levellers, Lilburn is the leveller who makes the greatest amount of appeals to Magna Carta and to sort of ancient constitutionalist ideas in general, but other levellers, people like Richard Overton or William Wallen, are much more sceptical, if not deeply critical, of these documents, seeing them more as actually examples of the way in which the English people had been subjected to kind of feudal bondage or vassalage, and so these weren't things to be celebrated at all. And obviously, if you look forward, look at Thomas Paine, for example, you've got a radical figure there who fundamentally challenges the whole idea, really, of the sort of the appeal to history as a sort of basic legitimating strategy in political arguments, or sweeping away all that material, or largely sweeping it away. It's not quite the Tony Hancock school of history of Magna Carta, did she die in vain? But I think there is a sense in which it's sort of in for example, in the debates over 40-day detention and so on, it's being invoked in a very kind of totemistic way. This is an assault on English liberty, like Magna Carta. But we're not really kind of unpicking what that means. I think because in a way, although there's still, I think, vestigial strength, that's a good way of putting it, to that kind of Whiggish narrative of gradually sort of increasing freedoms, largely achieved through the work of Parliament over the centuries. Although I think there's still quite a lot of sort of cultural heft to that idea, it's been losing its purchase over the past few decades or so, and I think that's to do with the fact that this is obviously a kind of triumphalist narrative, and it's a narrative that, in particular in the 19th century, was attached to ideas of empire as well, and Britain's position in the world. And as those concepts, those ideas have taken a knock, have been gradually sort of worn down, So the kind of intellectual and historical narratives that have been built on them have started to dissipate as well. So I think people are still kind of calling on those narratives, and you can still see them institutionalised in some ways in terms of school curricula to a certain extent. But I think they've got less and less resonance. They mean less and less to people because the things that they were built on aren't there or have diminished to such an extent that it no longer seems to make sense to talk in this way.
And therefore, do you feel that there's a slight tension between how some actors in the Magna Carta commemoration for 2015 are still appealing to this kind of Whiggish conception, and perhaps where we stand?
Yes, I think there is that tension there. I think there's that difficulty there in terms of also what people want to do with this rhetoric that they're using with these appeals to Magna Carta. If what they want to do is to sort of what they see as defend certain sets of values, there is the question about whether really they're defending things that have already gone, whether they're really values that actually exist anymore, whether it is healthy to try and reassert those values in the present day in this particular context. I think it can be, it can be counterproductive. Being counterproductive in the sense that it simply doesn't appeal to people. It doesn't make sense to them. And also I think it can be damaging in the sense, as I've said before, that this narrative does have these kind of discriminating and excluding elements to it. And that can mean that certain sections of society can feel left out of this story, can feel that it's a story that doesn't actually mean anything to them, that doesn't include them within it. I think going back to its sort of 13th and 14th century history, I think the development of a kind of a broader definition of rights from it is actually, that is an important intellectual, historical development, and that shouldn't be underestimated. So when we're talking about the kind of the mythologizing of Magna Carta, that shouldn't be taken to an extreme of saying that it's not an important document or that it doesn't contribute to the development of rights. And so I think the fact that it was already, if you like, a kind of a famous document in terms of English legal and political thought by the 14th century meant that it was this sort of very important resource to call upon in the 17th century, when England undergoes, and the British Isles in general undergo, another kind of crisis, major crisis of political authority. And because of the broader language of rights that's beginning to come in to that late medieval interpretation of Magna Carta, I think that then means that it can sort of transition from that medieval context into an early modern context, where understandings of rights are starting to shift towards something that we might recognise more as a kind of understanding of individual civil rights today. So I think there's that, I think the fact that it is an important document in its own time, and it is an important document in terms of changing understandings of rights. And I think also, this notion, this struggle between if you like, those who are representing the people, or seen as representing the people, and the executive and the monarchy, is a very powerful story. It's a very powerful narrative, and it can be applied in a number of contexts. In the 17th century, it's still largely being applied in the context of the representative resisting the authority of the monarch. But of course, as the authority of the monarch themselves declines over the 18th and 19th centuries, it then becomes used as, in more general terms, as a kind of weapon to defend the people from executive, arbitrary government, arbitrary power, and so on. So it's, I think that broader story about resisting overmighty power, whether that's the king, whether that's Parliament, is a very powerful one, and it's one that can be translated into a number of historical contexts. I mean, one recent example that really struck me when I was doing the research for the Radical History book was the example of the Chagos Islanders. And these were people who were moved off the island of Diego Garcia in the 1960s to make way for an American Air Force base. Now, they were people who held joint British and Mauritian citizenship, but they were expelled, most of them to Mauritius. One of the things that interested me about the case was the way in which their lawyer had felt that Magna Carta rights might protect them, because Cap 29 seems to suggest that British citizens shouldn't be expelled or exiled, from their country without sort of due legal process. Now, the thing that interested me about this was the way in which, as the case is developed in the 2000s, in fact, it wasn't actually those Magna Carta rights, if you like, which led to the Chagos Islanders having positive legal verdicts in their favour, in this case over their expulsion from Diego Garcia. What had happened was that the colonial governor of that British Indian Ocean territory was in fact decreed to have exceeded his powers, the terms of his kind of colonial mandate. So actually Magna Carta in that case hadn't really protected the rights of these joint Mauritian British citizens, even though they were given a legal verdict in their favour. And what interested me about that was actually seeing how Magna Carta, still in law today, doesn't really afford the protections that are sometimes sort of seen as being embodied in it. And that in fact, because it's really about guaranteeing legal due process, it's a document that's always going to be read in light of the law of the land at the time. And that then feeds into the usage of Magna Carta in things like the 40-day detention debates, where you get people like David Davis and Tony Benn saying, well, Magna Carta is being threatened, or Magna Carta is being killed off by this piece of legislation which is going to allow the government to detain people for 40 days without charge. And the problem with this, of course, is that that legislation was really only talking about extending the period of detention in any case from that already afforded by current or past, as it were, then anti-terrorism legislation. So it was really a question about how long is a piece of string, rather than can we do this thing or not. And so I think what that shows you is the way in which, as I say, Magna Carta is seen as preventing things like arbitrary imprisonment, but because it's a document that's read in the light of other pieces of English law, it in fact doesn't do that at all. And various bits of British anti-terrorism legislation and various other bits of British law certainly allow for certain periods of imprisonment without any formal charge. So that was very interesting to me in terms of looking at, if you like, the substance of Magna Carta in law today as compared to the rhetoric of it. Rhetorically, it's still being used to say that, you know, the sort of imprisonment without trial, this is something that, you know, we shouldn't have in England, Britain, because of Magna Carta. But when we actually look at legal cases involving all the substance of the law, it's quite clear that Magna Carta doesn't prevent forcible exile or imprisonment, provided those things are actually, you know, things that have been already ratified in law as permissible. I mean, I think that's, and I think actually during the 40-day detention debate, I mean, people like Tony Benn and David Davis are smart enough to know that to know, you know, what's really what in terms of the legal context. But as you say, it's rhetorically still a powerful thing to say that sort of, you know, basic fundamental English laws are being threatened by new anti-terrorism legislation. I suppose the other case, relatively recent case that I've come across where Magna Carta was invoked, which I thought was very interesting, and I think it feeds into current discussions, both sort of in the press and sort of popular history and politically, was the 1982 case, I think, of the Alberta Indians, and in particular Lord Denning's minority judgment in that case. So this was a case, if I'm remembering correctly, where certain First Nation groups in Canada were concerned about how the new Canadian Constitution was going to affect their rights, because they had had various direct treaties, these First Nation groups, with the British Crown, which had guaranteed them certain rights, and they were concerned that the new Constitution was going to dissolve those agreements and effectively, you know, weaken their status within Canadian society. And I think Denning's judgment really interested me because on one level, some of the things he says seem to fit into that sort of triumphalist narrative. There's a famous quote that's taken from it of Magna Carta follows the flag, and the idea that these sort of British liberties are sort of expanding outwards across the British Empire and the Commonwealth, gifting these freedoms not just to British people but to the colonised societies and the colonists themselves. But then there's another part of this minority judgment which I thought was really interesting, where Denning actually talks about the First Nations groups themselves. And what he says is that there's no reason really to think that Magna Carta is a superior sort of legal document to First Nation understandings of the law. Because he says if you see Magna Carta as essentially reaffirming customary law, then it's very similar to the kind of customary law that had governed First Nation societies in Canada and in North America generally. And so what he's saying is, well, we can't say to you that our law is better than your law because we both feel that customary law is important. And I thought that was actually, a really kind of radical statement to come out from Denning. I think part of the problem with that narrative about sort of Magna Carta and other sort of British conceptions of rights being expanded out through the empire is the idea that they're going into a kind of legal vacuum. That the societies that are being colonised don't have any understanding of law or freedom, but luckily we came along and gave it to them. And actually what Denning was saying is no, Native Americans think custom law is important, so do we. They've got their custom law, we've got our custom law. And I think that understanding is absent actually from an awful lot of the discussions of Magna Carta's international influence. It tends to be seen as this wonderful gift that's sort of given to colonised peoples, that we're giving them this understanding of freedom and liberty. Whereas I think really that narrative itself is part of that colonising project, because it's saying these people don't have law, therefore it's okay for us to colonise them and take their land, take their property, take all other sorts of stuff, because actually they haven't got any legal entitlements to it as far as we can see. So that sort of particular case was really interesting to me, not so much in terms of the famous quote, but actually that statement about customary law and actually how it's important to indigenous groups in terms of their own custom law as well as to English conceptions of the law. Well, in the first place, we can see, as in those cases, the case of the Chagos Islanders, that in practical terms, Magna Carta often doesn't afford much protection to indigenous groups when they are, if you like, at the sort of the hard end of imperial strategy in some way. It doesn't really afford them much of a defence against whatever the British government happens to want to do at a particular time. But then I think there's that broader sense in which there is still, as I say, that powerful narrative about British constitutional development, which talks about its uniqueness, its distinctiveness, and its superiority, and sees it as this wonderful contribution to global as well as British civilization, as if what was driving British colonisation was actually a desire to confer rights to various groups around the world. Now, I think most historians of British colonial expansion would argue that trade and commerce were probably kind of more important initial drivers than a real hunger to export civil human rights anywhere. But I think that narrative is still a very powerful one, and it's one that has, I think, been sort of resuscitated and recovered as an idea of kind of British freedom or British liberty is seen to be under threat from increasing immigration, from extremism of various kinds, and so it becomes this kind of defensive reflex where you sort of say, well, we've got to defend this conception of British liberty from all these kind of external, foreign, and domestic threats which are threatening to kind of destroy and dissolve our very being as a sort of free liberal democracy. Now, that's not to say that some of those threats aren't very real, or that there aren't problems. But again, I think it's about the cultural assumptions that go along with that, and it's about the way in which that kind of narrative excludes and denigrates the cultures of other societies and the cultures of other groups. I mean, you can find that in even in the sort of recent discussion of Human Rights Act, the idea that this is sort of a foreign importation, of course, missing the point that most of that document comes from a document that was actually framed with a good deal of British involvement in it, a European Convention on Human Rights. So it's this sort of language about a kind of exclusive native set of rights, I think is dangerous, and can be put to all sorts of I think not very good political purposes. The American example is the most striking example of the way in which, of course, this language about British rights and British liberties can be used in a variety of ways and be read in a variety of ways, and can be used against, as you say, against the colonial power. So seeing Magna Carta as ensuring that there should be no taxation without representation, and seeing, for example, the Bill of Rights as guaranteeing you a right to arms, you're using all of this, British inheritance, imperial inheritance, to actually resist imperial power. In the same way, I think, as I say, I think in in more recent times, we found various groups using Magna Carta, whether it's Alberta Indians or whether it's the Chagos Islanders and their lawyers, using this language of Magna Carta rights to defend their own conception of rights, to defend their own sort of right to live in a particular area. So clearly, as I say, although this language can be used to legitimise colonialism and the appropriation of land from indigenous groups, it's also a resource for those groups themselves to turn back on imperial authority. And that's something, I think you can see that in terms of a process internationally. And you can't really write the history of the Haitian Revolution without talking about the way in which those revolutionaries used the language of the French Revolution for their own purposes to resist French colonial authority. So these kinds of languages about rights and liberties are always open to appropriation and exploitation, sometimes by those very people who are meant to be either excluded or actually subjugated by those particular rights. Look at the way in which the suffragists and suffragettes used Magna Carta in the 19th century. This is not a document that was really concerned very much with the rights of women politically or in society in broader terms, but they were using that language because it was such a kind of integral part of British historical and political tradition to advance their own claims, to make those arguments about women deserving the vote and other political rights. It's less a question, I would say, of it's always a issues as a historian of England, then you immediately we end up with the B word in there as well somehow. And of course, you're dealing with a document which, in its original form, was created in a time when neither of those entities actually made all that much sense necessarily, and certainly the idea of the nation state hadn't really come into being. So we're really translating these sort of modern conceptions into this medieval document. Then there's the question about, well, if it's a part of British values, or whether we're going to have a British Day and we're going to have that held on a day when Magna Carta was supposedly sealed at Runnymede, whether that's appropriate. I think I don't think that's necessarily, although maybe Welsh, Scottish and Northern Irish people might disagree, I don't necessarily think that would be something that might sort of irritate a lot of people, and I wouldn't be so concerned about that being the issue. I think it's more a case of if you're talking about, as often is the case when people talk about British values of tolerance and fairness, what do you actually mean by fairness and tolerance? Because if you were to look at Magna Carta, what does Magna Carta say about tolerance? What are all those clauses about Jewish moneylenders about, if it's a document about tolerance? And I think we really, I'm coming back to that sort of point about it sort of being a kind of totemistic invocation of it, and also just a not very reflective discussion of what these values are that we're talking about. If you're talking about tolerance, it really doesn't kind of emerge as a concept in an English context until the very late 17th century. Anything that we would kind of recognise as an ideal of religious tolerance, and even then that ideal is heavily contested, and an awful lot of people don't think you should tolerate different religious groups. They think that that's terrible and amoral, and all sorts of bad things will result from being tolerant of different religious groups. So I think just using it in that kind of very broad brush way, saying, we believe in fairness and tolerance, and this is embodied in Magna Carta. Well, where is it in Magna Carta, and what do you mean by these concepts? I think if we would actually have a discussion about what we mean by tolerance, that might be worthwhile and interesting. But just to say that British people are tolerant and fair, and we can prove it because we've got Magna Carta, doesn't really mean very much. And in fact, I think it's unhelpful. I think it again, it encourages this sort of often undeserved sense of sort of British sort of specialness and uniqueness in terms of the history of the development of rights. So I think that's the danger of talking about sort of Magna Carta as a British document rather than necessarily that Welsh people or Northern Irish people or Scottish people might prefer a different day or document to sort of venerate and celebrate. And I think that, obviously that then feeds into what we think about Magna Carta in international terms as well. Clearly it has made an enormous contribution to the constitutions of a number of countries, and the Constitution of the United States is the most obvious example there of its sort of intellectual contribution. And that's, so I don't want to kind of diminish that or say that isn't important in international terms. But then there's a way of kind of discussing that influence, and the way of discussing it where you're only ever talking about it as this sort of beneficial donation of the mother country to all of its colonies, I think is, well, I mean, I can't put myself in the mind of of somebody coming from one of those countries, but I'm not sure it's necessarily the most helpful way of talking about Magna Carta's international contribution either. What's Magna Carta's balance sheet? I think that's a very good question. I think it's in the positive side, broadly speaking, and I would say that because I think actually, as I mentioned earlier, I think it's probably the best example you can have of a document which has been central to political discussions across such a broad period of time and across a range of geographical contexts. And although that discussion itself may involve anachronistic elements, say historical elements, may distort the meaning of the original charter, those mythologizings, misrepresentations have had significant impact upon how we've developed as a country and how other nations have developed as well. I think most of all, they also show us that despite what is said of Magna Carta, in fact, constitutional debate and debate about rights and liberties is an ongoing thing, and it's a living thing, and it's determined by the particular context of that particular historical moment. And so I think actually, the mythologizing is just as important as the substance itself, because it shows us those changing contexts. The way in which Magna Carta is being talked about in the 19th century is very different from the way in which it's being talked about in the 17th century, let alone the 14th century. And those different contexts, those different discussions show you the changing priorities of people within that time in terms of their rights. The 19th century, it's obviously much more important to people to discuss individual voting rights, to discuss the notion of a kind of welfare state and a kind of safety net for people. In the 17th century, it's much more important to talk about checking executive power. It's much more important to talk about individual liberties like freedom of conscience. And then in the 14th century, you've got a whole different discussion of rights again. So I think that's the real, value of Magna Carta for me. And I think one of the ways in which this anniversary can be important is actually just reminding people that discussions of rights and liberties are not kind of frozen in the past. They're not done and dusted with. They're things that continue to get revisited, repackaged, and argued over the centuries. And we should continue to kind of reevaluate, reinvestigate, and reflect on our own constitutional democratic history and think about that and think about what that tells us about, our needs in the present. The whole problem is that when British values are described, they're invoked rather than discussed, aren't they? British values are fairness and tolerance, and if you're not fair or tolerant, then you're not behaving properly. And it's it's kind of meaningless to a certain extent as well, where you sort of say, British values of fairness and tolerance. Well, what society doesn't want to describe itself as fair and tolerant? I'm sure North Koreans can describe themselves as being, fair and tolerant. It doesn't really add very much unless you start to say, what does it mean to us? What do we mean by being tolerant? And I've talked about this with my students because it's sometimes really hard to get them to actually discuss these kind of what seem like abstract principles at all. And I was trying to get them to discuss tolerance because we were looking at all these sort of 17th century texts relating to tolerance. They find it really hard because the language is sort of arcane and they can't really get loads and loads of biblical references and references to medieval legal texts, for example, within it. Can't sort of grasp that at all. And then you say, okay, well, what do you think about? What do you think tolerance means? And it's quite interesting. I mean, they thought tolerance was sort of, was too pejorative and kind of implied that you were only, which is correct actually. If you're thinking about the actual sort of etymology of it, that you're only really putting up with an opinion or a behaviour that you don't approve of. Whereas, in fact, it should be much more positive about, celebrating difference and celebrating, acknowledging that diversity is a positive thing and, pluralism is a positive thing. Oh, that's good. Then you can start probing them on it and saying, okay, well, what about, I gave them a slightly less kind of, possibly less combustible one than sort of talking about, I don't know, radical Islam or something like that, where, groups that don't tolerate view other religions as anathema, as blasphemous or so on. I gave them the example of the Naked Rambler. You heard the Naked Rambler? He's this guy who's been in prison for years. He was recently released but has gone back into prison. He just rambles around the country naked. He doesn't, so he's not kind of exposing himself to people. He's not deliberately going up and exposing himself, but he does just wander around with no clothes on, and he doesn't alter his route in any way so as to sort of minimise potential offence. So he will walk past schools and so on, if it's on his route, stark naked. And this has led to, public outcry and people phoning the police when he appears. And so he's been in prison for years because of breaking, being viewed as sort of a threat to public decency or being seen as a threat to public order. But I said to the students, but aren't his rights being infringed? He's not even advocating nudity most of the time. He's just wandering around naked. He's not interfering with anybody. He's not kind of exposing himself in a sexual way to anyone. No. So should he be in prison? We've got these freedoms of sort of freedom of conscience, freedom of speech. But then, if you're looking at the letter of the law, you come to things like public decency. As you say, these are really quite vague concepts. And they've changed over, very recent history. What was viewed as public decency in 1950 is not the same as what was viewed as public decency in 2014. So...